Be ready. Start. Now, if the public servant holds two offices and he is accused of having abused one and from which he is removed but continues to hold the other, which is neither alleged to have been sick, misused, nor abused, is a sanction of the authority competent to remove him from the office, which is neither alleged or shown to have been abused or misused necessary. The submission is that if the harassment of the public servant by a frivolous prosecution and criminal waste of his time in law courts keeping him away from discharging public duty are the objects underlying section 6, the same would be defeated if it is held that the sanction of the latter authority is not necessary. The submission does not commend to us. We fail to see how the competent authority entitled to remove the public servant from an office which is neither alleged to have been used, sick, misused, or abused would be able to decide whether the prosecution is frivolous or tendentious. An illustration was posed to the learned counsel that a minister who is indisputably a public servant greased his palms by abusing his office as minister and then ceased to hold the office before the court was called upon to take cognizance of the offense against him and therefore sanction as contemplated by section 6 would not be necessary, but if after committing the offense and before the date of taking of cognizance of that offense he was elected as a municipal president, in which capacity he was a public servant under the relevant municipal law and was holding that office on the date on which court proceeded to take cognizance of the offense committed by him as a minister, would a sanction be necessary, and that too of that authority competent to remove him from the office of the municipal president? The answer was in affirmative, but the very illustration would show that such cannot be the law. Such an interpretation of section 6 would render it as a shield to an unscrupulous public servant. Someone interested in protecting may shift him from one office of public servant to another and thereby defeat the process of law. One can legitimately envisage a situation wherein a person may hold a dozen different offices, each one clothing him with the status of a public servant under section 21 IPC, and even if he has abused only one office for which either there is a valid sanction to prosecute him or he has ceased to hold that office by the time court was called upon to take cognizance. Yet, on this assumption, sanction of 11 different competent authorities, each of which was entitled to remove him from 11 different public offices, would be necessary before the court can take cognizance of the offense committed by such public servant while abusing one office which he may have ceased to hold. Such an interpretation is contrary to all canons of construction and leads to an absurd end product which of necessity must be avoided. Legislation must at all costs be interpreted in such a way that it would not operate as a rogue's charter. We would, however, like to make it abundantly clear that if the two decisions purport to lay down that even if a public servant has ceased to hold that office as public servant which he is alleged to have abused or misused for corrupt motives, but on the date of taking cognizance of an offense alleged to have been committed by him as a public servant, which he ceased to be, and holds an entirely different public office, which he is neither alleged to have misused or abused for corrupt motives, yet the sanction of authority competent to remove him from such latter office would be necessary before taking cognizance of the offense alleged to have been committed by the public servant while holding an office which he is alleged to have abused or misused and which he has ceased to hold. The decision, in our opinion, do not lay down the correct law and cannot be accepted as making a correct interpretation of Section 6. Further, under Section 19 of the PC Act, sanction is to be given by the government or the authority which would have been competent to remove the public servant from his office at the time when the offense was alleged to have been committed. The question of obtaining sanction would arise in a case where the offense has been committed by a public servant who is holding the office and by misusing or abusing the powers of the office he has committed the offense. Thank you.